Breaking tonight out of Minneapolis, Derek Chauvin's attorney asking for a new trial for the former police officer convicted of murdering George Floyd. Eric Nelson filing a motion on multiple grounds, including jury misconduct and, quote, in the interest of justice, arguing that the publicity here was so pervasive and so prejudicial before and during this trial that it amounted to a structural defect in the proceedings. There are a number of arguments in this motion, but our question, is it legal? Let's bring in attorney Ethan Bearman and criminal defense attorney David Bruno. Great to have both of you back, gentlemen.
Hello, Shannon.
Hi, Shannon.
Okay, let's start with this thing that's getting so much attention. It's a picture of one of the Chauvin jurors. His name is Brandon Mitchell, I believe. In a picture, he is wearing a shirt that says, "Get your knee off our necks." He was part of a march here in Washington. But here's something that was one of the questions on the jury questionnaire. And according to the Star Tribune, who talked with Mitchell, he says he answered no to this question. Have you or anyone close to you participated in protests about police use of force or police brutality? Now, with that picture in mind, he says it was his uncle that posted it on social media, and that it wasn't, he doesn't remember the shirt or recollect that he owns it or that he wore it. And he went on to tell the Star Tribune the event was 100% not a march for Floyd. He said it was directly related to MLK's March on Washington from the 60s. The date of the March on Washington is the same date. We do know that George Floyd's family members spoke at this event. But, David, is any of that enough for grounds for a new trial?
Yeah, well, Shannon, the excerpt that you just showed actually did not have the back half of the question, which says in D.C. And that's a problem for the defense because it's inartfully worded. So he really did answer the question accurately. And I think this falls on the defense attorney because he should have had a carefully crafted jury instruction or a question there that expanded not just Minneapolis, but any city, because then he would have been required to answer that question. You know, so I look at it as maybe ineffective assistance, but it is very troubling because if that were known to the defense team, the shirt and what it said on it, there's no doubt that that court would have struck this individual juror for cause. And the defense had peremptory challenges left, meaning they could have struck the juror for any reason, absent gender, race, or protected discrimination issues. You know, so this it smells, but at the same time, he did answer the question correctly.
Well, and that's the job of attorneys when they're vetting and going through voir dire and asking jurors about all kinds of personal things because they want to make the best decision regardless of which side of the argument they're on to make sure that they have the best shot for the case they're going to try to make. But Ethan, this motion today asking for a new trial mentions all kinds of other things about the fact that there should have been, they argue, a movement of venue. This should have been held somewhere else. There was no way anybody could have been pulled from this jury and not have been overwhelmed with information and messaging about what happened with George Floyd, the resulting riots, all kinds of things, and the fact that the jurors were not sequestered. Do either of those things gain traction?
Yeah, again, I was a little surprised that there wasn't a change of venue, but that is really at the discretion of the trial court judge. Appeals courts give great deference on that type of a decision to the trial court judge. So again, I was surprised that there wasn't a change of venue. But the second part of this is in today's world where we have 24/7 news, social media, really, does that change the outcome by moving the venue anyhow? I don't believe that there's enough evidence here that any court is going to require a new trial because of venue or sequestering. I just don't see it rising to that standard.
Well, what about that, David? Because, you know, a lot of folks have, on this question of venue, have said, listen, this is the city where these terribly painful, horrible things happen, from the death of George Floyd to businesses that were looted and burned down and destroyed, neighborhoods full of fear, that it would be hard to have this trial in that city when so many people, connected and not connected to the actual death of George Floyd, were impacted in some way.
No, I could see the argument, but let's look at the Boston bombing case. I mean, you don't get a case that should have been transferred because you had the citizens there that were actually forced to stay home, you know, in Oklahoma City. And the list goes on and on and on. I agree. I don't see it as an appeal. I think the biggest issue on appeal is the jury instruction on the second-degree murder. I mean, that was essentially a felony murder type statute. And the jury was instructed that the defendant didn't have to have a specific intent to injure on the assault. So if we're searching for issues on appeal, I think it's what happened today with the shirt. But even more so, I think it's going to be on that second-degree murder, the highest charge, on what the jury was given as an instruction on the mens rea that was required.
And just so people know, this is a motion for a new trial. The appeal could be another step as well, but there are a number of ways that the defense will go after this and try to get some kind of relief for their client who's already been convicted on all the counts. Quickly, back to this juror, Professor Jonathan Turley says this: the defense will have the same uphill battle in the Chauvin appeal, and the question is whether there's anything in addition to the photo. It will also have to be prepared to answer, as in the Roger Stone case, why it did not perform a full internet search on prospective jurors. I mean, Ethan, did someone drop the ball in not scouring social media more thoroughly in vetting these jurors?
I mean, that's potentially an argument, and again, that falls on the defense. However, you know, the amount of resources that you put to scour every single potential juror's full social media network is a little over the top. But I will say the Supreme Court has a number of rulings, you know, from the 1960s all the way through 2017, where the juror misconduct is very narrowly defined. It needs to be egregious. It needs to be clear. It needs to be specific. It needs to be an overwhelming number of jurors. Again, I just find it very unlikely in this case that this juror wearing that shirt at that event in D.C. changes anything. I just don't see it rising to that standard.
Well, we'll see. I know that in Minnesota, as in many states, there is an opportunity to call in a juror and have a more thorough vetting and explanation of some things. We'll see if that happens in this case with Brandon Mitchell. In the meantime, Ethan and David, thanks for lending us your expertise.